I call the first case on this morning's docket, case number 116371, State of Kansas v. Stephen A. Gentry.
May it please the court, Peter Meharry for Stephen Gentry. If I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. In this case, Mr. Gentry was ultimately convicted of first-degree murder, attempted first-degree murder, criminal discharge of a firearm, and conspiracy to commit aggravated battery. The events that led up to those charges started on May 5th, 2015. At that time, Mr. Gentry had an altercation with his then girlfriend that led to her calling the police. She then left the apartment but returned the next day with some family members to retrieve her belongings. On May 6th, when she came back, there was an altercation between her family members and Mr. Gentry and some of his friends. Ultimately, Mr. Gentry was punched in the face. Then his girlfriend got her stuff and left. Mr. Gentry then, with several of his friends, went to look for her family to get revenge. They drove by the house they thought her family members were at, parked about a block away, walked back over, but all the lights were off, so they thought no one was home. As they went back to their car, they saw a pickup driving down the street where they were at. They knew that his girlfriend also drove a pickup. As the pickup drove by, there's somewhat of a dispute in the evidence, but shots were fired at the pickup, ultimately striking a girl by the name of Allie Som, and she died of those wounds. Her and the other individual in the pickup were completely unrelated to the altercation, and the state charged, as I said before, first-degree murder for her death, attempted first-degree murder for the shooting with regard to the driver of the vehicle, criminal discharge, and conspiracy to commit aggravated battery. We've raised several issues in our brief. The focus of those issues are on the lesser included instructions and the ones that the district court did not give to the jury. It is our contention that the district court failed to give instructions that were both legally and factually appropriate in this case, and certainly we believe would have made a difference in the ultimate verdict the jury would have rendered. Specifically, at trial, defense counsel did request reckless second, reckless involuntary manslaughter, and then also voluntary manslaughter be given. The district court declined to give those. In declining to give those, the district court did state, and this is from volume 13, page 954, the court's going to find that shooting a firearm into an occupied vehicle as it's being driven down the street right in front of where the defendant and co-defendants were located is an intentional act as opposed to a reckless act.
And there was no tying the intentional act to a killing. It's just an intentional act of, I think the trial court judge focused on the firing of the weapon as opposed to any other act is designed to kill someone.
Certainly that, from the court's comments, he was looking at whether or not he intentionally fired the gun, not whether or not he had an intent to kill the individuals in the truck. And we believe a couple of things are wrong with that view, is that this court has said when you deal with first-degree murder and second-degree murder, the intent is the intent to kill. And this court has also said that an intentional act can be done recklessly. And I would point this court to the Cordroy case, where this court looked at whether or not there was sufficient evidence for reckless second-degree murder in that case, and it involves circumstances very similar to this case, firing a gun at a vehicle at night.
But the other way to look at what the judge said is that a person that uses a firearm and discharges it directly at a vehicle gives rise to no other inference than an intent for that bullet to do what it does, and that's
I think
Kill.
that could be a conclusion of the jury, that that was the intent. The intent was there to kill. But I think when you're looking at instructions, the question is not what you believe the evidence shows, it's what could be supported. And I think there is evidence in this case, shooting a gun at night at a moving vehicle supports also a conclusion that this was a reckless act.
that they were trying to scare him off, or
Right. And there was evidence that statements from Mr. Gentry that he never had any intent to kill anybody. They were looking just to get revenge, but nothing beyond that. Again, this was shooting at a moving vehicle at night. There was testimony that there was no street lights along that street. So we believe that there is evidence that could support the finding of recklessness in this case. And, you know, we haven't raised a sufficiency argument. I know the state noted that in our brief, because there is evidence to support both intentional intent to kill and reckless.
And is that evidence of intent to kill just circumstantial, at least on the part of the shooter? I mean, what evidence do we have about the shooter's intent other than circumstance?
Well, the state's argument was that he was looking to go back, get revenge, and kill. And that intent to kill was throughout the evening with Mr. Gentry. And that's why the state's argument was he yelled shoot as the vehicle passed, and it's their argument that that was with the intent to kill.
So when you said he there, you're talking about Mr. Gentry.
As far as this case goes, yes. That was the
But
state's argument at trial.
How do we layer the intent of the shooter with the intent of Mr. Gentry? If the shooter didn't have the intent to kill, can Mr. Gentry be liable for these crimes?
I think under accomplice liability, I think he could. And certainly I think the state's argument at trial was he had that intent to kill, and that transferred to the actual shooter in this case. And that's why he could support intentional first-degree murder.
Isn't transferred intent about transferring intent toward the person who's the target? It's not about among accomplice and principal, is it?
Usually, my understanding of a transferred intent is I intend to shoot person A, I shoot person
And you
B.
shoot person B, right. It's about the target, not about the person and the principal and the accomplice.
True, but my understanding of the state's arguments and their position in this case is that my client had the intent to kill when he ordered Mr. Palacio to shoot.
I understand that's the state's position. I think what my colleague is trying to ask you about is what should we care about? Both the shooter and the defendant?
For our argument, what I think this court should care about is the facts that support reckless conduct. And I don't think that necessarily
let me
entails-
rephrase it. I think everyone's talking past each other.
Yeah.
The Gentry, if the state's position is Gentry told the actor shoot,
Correct.
wanted him to shoot because he wanted to kill the occupants of the vehicle, but the actor was trying to shoot the tires out. Gentry said shoot, and so his intent was to shoot the tires out and stop the pickup so they could beat him up. So one had the intent to kill, the other one didn't have the intent to kill, and we're asking how does that play out, I think is what we're getting at here. Did the actor have to also have the intent to kill, or only Gentry? Isn't that what we're asking?
Yes.
What I was trying to ask, yes, thank you.
I apologize for not following. I guess I don't know. That is not our argument. I frankly had not thought about that preparing for argument. My focus was on the intent of Mr. Gentry and whether or not there is evidence that his intent was solely the intent to kill versus whether or not he was just yelling shoot to scare him. As far as that evidence goes, I believe there is sufficient evidence to show that this could be viewed as reckless conduct to support that lesser included instruction.
So are you giving up on the factual dispute that Gentry said that's not the right pickup, don't shoot?
No, I'm not. I
You're just
try
saying
to point out.
even under the state's best evidence, it still doesn't meet the mark for, or that even under that evidence, there should have been a lesser included.
We think when you look at the evidence as a whole, there is contradictory evidence as to what my client said. But either way, I think if you look at the evidence, it shows that this could be viewed as a reckless act, not solely as an intentional act, which is what I think the district court looked at it as. And the district court, in making that finding, said this is intentional to the exclusion of these lesser included reckless offenses. So I think even with the disputed testimony, you have a sufficient basis under the statute. There is some evidence there that this is a reckless act to support that instruction given in this case.
Well, that was his statement in his statement to police, which was offered to the jury, was that he never intended to kill anyone that night. He just was looking to go get some form of revenge or to confront the people that attacked him.
That was within his statement, that he had never had any intent to kill, that this was just to get revenge for getting punched in the face earlier in the day.
What do we do? Let's say we agree with you and we say, yes, there should have been an instruction on some form of reckless conduct. What happens to the attempted murder convictions, the attempted first-degree murder convictions? Because there is no such thing, as we've recognized, as attempted reckless second-degree murder or attempted reckless involuntary manslaughter. It seems odd that those crimes would stand because there's no lesser for those in terms of reckless, but we would send it back on the reckless conduct. What do we do with that? And what do we do with that?
Certainly we've argued in our brief that actually there is reckless attempted second degree. I understand this court has said otherwise, and I'm certainly recognize the fact I'm fighting upstream on this. But it's our contention that with changes to 5202, the legislature has equated or shown that if you have intentional conduct, you have proven reckless conduct, which allows for attempted reckless second. Secondly, if this court does not agree that there is such a charge, I think that conviction stands, and whether or not that seems a little bit illogical, I think the actual fault for that would be that the attempted second and the criminal discharge really should have been alternative charges. Either this was a reckless act or this was an intentional act. And if it's reckless, it's criminal discharge. As we pointed out in our brief, the jury convicted of that. That requires finding reckless. I understand.
Having something stand, the same conduct gives rise to an intentional act when it comes to the attempted killing, but it's a reckless act when it comes to the actual killing. That just doesn't make sense to me.
And Your Honor, maybe it doesn't, but as we sit here right now, that's what we have. Because we do have a criminal discharge conviction, which is based on reckless conduct for the very same act that is the basis for the first-degree murder conviction and the attempted second. So we have that as we sit here today. And as I said, I think probably if you want to keep things logical, the criminal discharge should be an alternative count. And I understand under the way we do multiplicity that they can do it the way they did it. But we have that kind of illogical setting right now. So even if this court finds that, okay, there's no attempted reckless second, and that conviction stands, this court can't just turn away and say, well, it doesn't make sense to keep that one and not keep the first degree murder. There is a basis for reckless second, and by extension, reckless involuntary manslaughter. And they should have been given in this case, and it's our belief that it cannot be viewed as harmless because there is sufficient evidence. The jury already found reckless conduct in the criminal discharge charge, and it would have given that jury another option, and we believe they would have taken it. I see I'm out of time. I just would request whatever remaining I have for rebuttal.
Do we have any further questions?
I'd like to give you a chance to explain to me your argument under 215202B, or C, I mean. Because as I understand it, you're arguing that proof of the higher intent of a higher culpability then gives you the right to the lessers.
Correct.
But that statute reads, proof of a higher degree of culpability than the one charged constitutes culpability of the crime charged. How do you get around the crime charged language of that statute?
I understand the first sentence says proof of a higher degree of culpability than that charged constitute proof of the culpability charged. It then goes on to say that if recklessness suffices to establish an element, that element is also established that if a person acts knowingly or intentionally. That second language doesn't have any caveats to it. It doesn't restrict it in any way.
So we
it
have
just
to-
says, I'm sorry, it just says if you need reckless and you prove intentional or knowing, you have proven reckless.
So you have to uncouple that from the context in which it's stated. You have to separate those two sentences from one another, not read them together.
I don't read them together, and if they wanted to limit it, they could have certainly limited the second and third sentences in that as well, but they didn't. So the way I read it, if you establish recklessness, or if you establish intentional conduct or knowing conduct, you have established recklessness under this statute. And it doesn't simply apply to the crime charge. It does apply to lessers, because I think if you read the second and third sentences, they are not restricted in that way.
Doesn't that defeat your argument on the recklessness required for the shooting in an occupied vehicle? Because it says that if you establish recklessness, it still also establishes knowingly and intentionally. So that just because of that particular crime satisfies, they found it to be reckless, it also could be intentional.
Your Honor, I think the way the jury was instructed, though, was simply you have to find this was reckless conduct, and that's what they found. I don't think there was...
But you're relying on the statute to say one thing in one instance, but not in the other.
I don't believe I am. What I'm saying is when you have established intentional conduct, you have established recklessness. That was not how the jury was instructed. The jury was simply instructed, this is criminal discharge. You have to find that this was done recklessly. They weren't told, if you find that he acted intentionally, you therefore find he acted recklessly. They were simply told you have to find that this was recklessly done. And they did do that. So I don't think this statute undercuts that argument in that manner.
Any more questions? Thank you, counsel.
Thank you.
Good morning. May it please the court, Ellen Mitchell on behalf of the state of Kansas. There were 5 co-defendants in this case, and each of their cases resolved differently, and 2 of them at trial, and we had different witnesses and different things happen, and so it's a little difficult for me to keep in my mind which case happened what, and I will do my best.
Just right off the bat, yeah, there are separate cases here. Can we ignore that in Mr. Palacio's case, who is the shooter in this whole deal, was instructed on reckless second degree. He received a lesser included instruction on that theory. And if he got that instruction, given the evidence in the case, why can't Mr. Gentry, and I know it's not, Gentry was tried first, so all that evidence wasn't in, but just how is it that if there's a transferred intent here, that he doesn't get the benefit of that kind of theory when that's what Mr. Palacio raised and was given the benefit of that instruction?
And I mean, and that's something that the judge determined.
And the judge only focused on the intentional act of shooting the gun. And in fact, there was some clarification about that. And that's all that she said.
And in Deal, we learned in Deal that the intent was the intent to kill and not just the intentional act in this case. And that's why we hopefully focused on what evidence there was to support the intent to kill, and that it wasn't a reckless act, that it was an intentional act.
But
So,
in the trial of the person who was the shooter, there was sufficient evidence at least to give a factual basis to give that instruction.
and I don't think that we can do that, though. And that's part of the difficulty I had in coming here and doing 3 of the cases right in a row was,
Right, yeah.
can we look at Palacios, because we're not going to be able to look at what Palacios statements were to use in Gentry's case and that sort of thing. We don't have the ability to do that. The witnesses weren't the same in both cases. Some witnesses showed up for one but not the other, and so they were tried and the evidence came in a little differently in each of the cases.
And the touchstone is some evidence from which a jury would reasonably convict. And you're saying that the reason there could be some evidence in Palacios' trial and not in Gentry's is because the evidence was not the same. Is that what you're saying?
Correct. Their statements weren't the same. They didn't.
Okay.
The witnesses weren't necessarily the same. And we in Gentry wanted to focus on what evidence was there of intent to kill, and that, first of all, Gentry's the one who put this whole thing into motion. He was the one that had the fight with his girlfriend. Her family came over. He was the one that had his glasses broken. There was one blow that actually made contact in the evening fight. He's the one that was out for revenge. He specifically requested Palacio bring a gun. A gun is a deadly weapon. If you're just going for a good old-fashioned fist fight, let's go over, hey, they punched me in the face, let's go back and get him tonight. There wouldn't be any need to bring a gun. They discussed getting quarters to put in their hand so their blows could be stronger. They talked about bringing a baseball bat. Gentry specifically directed Palacio to shoot, and he didn't limit that directive. He didn't say shoot in the air or at the tires. There were multiple shots fired, not just one to scare him away, not one in the air. They all went in the direction of the moving vehicle. And remember, this didn't happen at Gentry's place. This happened when they went to the neighborhood where his girlfriend's mother and boyfriend lived. He was in their neighborhood. There wasn't any need to shoot once to scare them away because they were in the victim's neighborhood. They were the ones, this vehicle's driving down the street and moving away from them. They didn't have any need to shoot or scare them, whatever. And the state argued and believed that all of those things show an intent to kill. You shouldn't fire multiple shots in the direct somebody to shoot and then have them fire multiple shots.
Counsel, given the conviction for discharge of a firearm
Into an occupied vehicle?
I'm just trying to figure out how all this matters. Aren't all the elements of felony murder present?
They are.
And so,
In this case,
why isn't this just, even if this is error, would it be harmless?
Yeah. And what's difficult also in this case is the jury found attempted premeditated as to Mr. Johnson, the driver, Allie's boyfriend. And they split in the first-degree murder charge with some finding premeditated, and their verdict said a combination thereof. And we don't know what the jury was thinking. Can only suggest that maybe some jurors thought this was more appropriate and some thought this, but we don't know if all of those that thought premeditated also thought felony murder. And so that's kind of what is difficult, is that the way the jury verdict came out. And is that because the state didn't do a good enough job in explaining to the jury?
Why does that matter?
Or not?
Why does that matter if now, from where we are now in the case, we have a conviction of a forcible felony?
Right.
And we have a death that resulted during the commission of a forcible felony. Could any reasonable juror not find the elements of felony murder were present?
I would agree with that, but maybe the jury's verdict doesn't show that by saying.
That's not the right question for us though on review, is
Right.
it? We ask whether a reasonable juror could have
Right.
reasonably affected the outcome.
And it was sentenced as the felony murder sentence in this case, so it wouldn't impact that either. The other thing that I want to touch on is...
Would you just back up here, explain that to me? So the jury was instructed on first-degree murder, both theories.
Yes.
And the verdict form had a place for unanimity on premeditated first degree, unanimity on felony murder, and then not
A combination thereof.
Yeah, some sort of combination thereof, and they went the combination.
Yes.
It's just, what does that tell us then? That
And how do you justify that with a unanimous verdict on attempted premeditated murder for the other victim?
Correct.
And so what it tells me is that the state didn't apparently do a good enough job of explaining that instruction. That if all 12 of you think it's this, or all 6, and maybe we need to look at, maybe we should have asked them to place their numbers in there.
But you don't get overs. You don't get overs to explain. I think my colleague's trying
Correct.
to, that is a felony murder conviction.
It is.
Correct? And I guess at least why wouldn't we look at it from the standpoint of harmlessness?
Right.
If we have a conviction for discharging at an occupied that would have obviously supported the felony,
Correct.
and we're convinced that even if they had a reckless, they wouldn't have
And-
gone lower than felony.
And even if we had a felony murder conviction, then we wouldn't have any lesser instructions to have worried about either.
Right.
The other comment I had too about distinguishing the shooting into an occupied vehicle being a reckless act, again, reverts back to what we started the whole argument with here today. And the state sees the difference in that in the reckless shooting, it's talking about the actual act of shooting into being reckless conduct, whereas in premeditated, the intent to kill is what we're looking at, not the actual act of pulling the gun and pulling the trigger. That, as pointed out in Deal and all the subsequent cases. I don't have any other comments on the other issues. As this court is well aware, just very recently, we cited in the restitution, reimburse the county attorney's office argument, the Alvarez case, and at the time that we wrote this brief, the petition for review was pending, and the court has rendered its decision in that. And the only thing that it changed from the Court of Appeals decision is they made it clear that shall is the permissive shall, not the mandatory shall. And
Well, you would agree, though, the court costs aren't restitution.
I agree.
Yeah, you would agree with that. And
Right.
so there would at least need to be some determination as to whether the court costs could be taxed.
Right.
As opposed to the restitution of the other
Right.
items of restitution.
And-
You would, yeah.
I agree, and that was the document we send out a notice in advance, and we have changed the wording on that to say court costs instead of restitution, but that's what we had intended. We're working under that statute.
But wasn't the judge's order also restitution?
To crime
To-
victim, when he entered it,
Yes, the journal entry.
Use the word-
Restitution.
we
And
used
so
the
how do we
word.
correct that? Is that something that can be changed?
It's happened in other cases from Saline County.
Were you not pro tunc? How do you correct the order? The court entered an invalid order, right? Because you can't.
Because he used the word restitution.
Exactly.
And we didn't cite to the statute that was court costs.
So I don't see that being a nunc pro tunc. I see that being a correction of a legal error, mislabeling, don't you?
It was mislabeled.
Okay.
Thank you.
Counsel, before you sit down, I know that you probably are asking us to affirm the convictions,
I am.
but on the road to that argument, we've heard discussion about the felony murder conviction and what that might mean in terms of harmlessness. We've also talked about the difference between the intent to kill versus the intention to pull the trigger on the handgun. Can you summarize for me what your position is regarding those issues? There's been a lot of back and forth today, and I want to make sure I'm clear.
I believe that when the court is talking about intentional in the murder charge, that the law requires the court to look at intent to kill. And in determining intent to kill, you might consider pulling the trigger and pointing the gun and those types of intentional acts. But clearly it's the intent to kill. Looking at what's evidence there is to support that.
In the mind of the defendant,
Yes.
not the shooter.
Right? And I distinguish the reckless act required for shooting into an occupied vehicle by arguing in those, in reviewing that conviction, you do consider the acts and not an intent to kill, because there is no intent to kill in the shooting into an occupied vehicle. It's the act that is the wrongdoing or what causes the conviction, and not the intent.
And aside from the discussion about felony murder, you're arguing on the other side that there simply is not evidence that would reasonably justify conviction of any of these lesser included crimes?
That's correct. We believe that the evidence was, in this case, intentional.
Do we have any further questions?
Well, just briefly, you said the reckless act in terms of the shooting in an occupied vehicle. It's just the reckless act of shooting. Does that always support an attempted murder?
No,
Okay. And
it's a factual determination.
okay, so there's
And I think also in looking at the reckless second, unintentional, and the reckless involuntary, I keep going back to the Deal case, but it talks about in there that a killing that is not purposeful, willful, or knowing, but which results from an act performed with knowledge that the victim is in imminent danger, but death is not foreseen. And I don't think that's the case here. He shot multiple shots right into the back of the vehicle, and I think there's some conversation in there about the defendant's own self-serving statement doesn't necessarily save him. We felt that the evidence showed that the death of Miss Psalm was purposeful, willing, knowingly, clearly foreseeable when you shoot in there. And the fact that the defendant was not necessarily the best shot or a good shot, and the fact that he didn't strike her or Vince Johnson 5 times still doesn't save him either. It's his intent and his ability or lack of ability to hit his target is not, doesn't save him from an intentional act either.
Any more questions?
Thank you.
Thank you, counsel.
I just have a couple quick comments in response to Justin Rosen's questions about whether or not reckless discharge of a firearm into a vehicle is always attempted murder. I think the state said no, and that whether or not it's reckless is a question of fact. And I think that's, I guess, our real issue here is whether or not this was a reckless act or an intentional act is a question of fact. However, the way the district court instructed the jury, they never got to make that decision. And going back to some of the discussion about, well, we have a felony, a forcible felony, so isn't this all harmless because we could have felony murder? The jury did not unanimously find felony murder. I don't think this court should be able to step in and say, well, they could have. I don't think that's the standard. What this court has to look at is whether or not there is evidence that a jury could look at to support a finding of reckless conduct.
Well, that's for the error side of it. But for harmlessness, we need to ask whether or not the error impacted the verdict. And so to go your way, correct me if I'm wrong, but the way I see it now is we would have to conclude that there's some possibility that those jurors who indicated premeditated on the first-degree murder charge would have, if they had been instructed on the lesser, they would have abandoned their premeditated verdict, skipped over felony murder, and gone to recklessness.
And I think you have evidence to say that they would have done that. When they were given...
help me understand that, given the fact that all the elements of felony murder are clearly met.
All the felony murder, elements of felony murder, whether or not they were clearly met or not, the jury can reject that if they want to. And some of the jurors did. They were split on whether or not this was first.
Well, they only rejected it because they wanted to go with what in their minds may have been perceived to be the higher count, which is premeditated murder.
I think that is speculation on the part of this court, and I could say that they went with what they had. Some of them thought it was felony murder, some of them thought it was premeditated murder, but because they didn't have the third option of reckless murder, they didn't go for it because they couldn't. They were not instructed on that. And if you look at how they were instructed, the district court restricted the questions the jury was going to answer. They did not sit back there and say to themselves, was this reckless conduct for first-degree murder or second-degree murder, or was this premeditated? Because they weren't instructed on it.
How does
If
the-
they,
I'm sorry, go ahead.
if they would have been given that option, there was evidence to support it, and there's a reason to believe the fact that they convicted on criminal discharge, there's a reason to believe that they thought this was reckless conduct.
How do you square that with the unanimous verdict on attempted first-degree murder?
The problem with that is, again, they were not given a question as to whether or not this was reckless conduct. I know that there's an issue of whether or not there is attempted reckless second-degree murder. But what I think this shows is that when they're given basically one option, attempted first-degree murder, they took it. This was a case where innocent bystander died, 17-year-old girl. Acquittal is not really a realistic option. The jury is just not going to acquit because, well, we thought it was reckless, not intentional. They're going to convict. My client admitted he was there. There's no question that, some other guy did it. That's not the issue. The issue at trial was whether or not this was reckless or intentional. And when the jury wasn't given those options, they took what they were given. And in this case, they took attempted second. That somewhat dovetails into our due process argument that by restricting the lessers, you push the jury to convict even if they have questions.
How does the fact that felony murder no longer includes any lessers by statutory fiat? He was convicted of a crime that has no lessers, and we're here arguing about whether he should have had lessers.
Well, I don't think he was convicted of a crime that has no lessers because the jury split. There was not unanimity on the theory of first-degree murder. They just said first-degree murder, so some said premeditated, some said felony. And the fact that you have some saying premeditated,
Well, if we
that gives
reverse the conviction and remand, and the state charges him with felony murder only, what happens? He gets convicted, right?
he might. Obviously, there'd be a new trial. The state certainly has some control over what it charges.
There wouldn't be any question about a reckless. You said the problem here is that we had pre-med, felony, and reckless were the three choices. If he's retried on felony, there's one choice.
If that's what the state chooses to do, this court has said that the statute eliminating lessers for felony is fine, and that certainly would undercut any arguments on lessers. Whether or not the state does that, obviously that's not within my control. But we believe what was done, charging in the alternative, premeditated or felony murder, still warrants lessers, and they should have been given in this case. And we would ask the court, for the reasons
Just
stated.
real quick on your
Sure.
due process argument, doesn't that come into play when there's no lessers given? Shad v. Arizona speaks to a case when there's no other option given, and here there was a lesser given. You don't get an instruction on all lessers, but as long as there is a lesser, doesn't that take away the due process from the table?
I would disagree with that simply because the lessers given here were second degree intentional, and as I've argued in my brief, there's no difference between first degree and second degree in our view. And secondly, the real question again is whether or not this was intentional or reckless. And the jury could have been sitting back there thinking this really seems more reckless and it's criminal discharge, but we don't have that option. So despite those reservations, we are going to convict him for the higher offense because that is what our options are. So we believe it's still a due process violation by failing to give those lessers, which forces a jury to climb up the ladder and convict of a greater offense.
All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Clerk will take this matter under advisement.